Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the faith based nonprofits. This week is one of our more exciting episodes as the Supreme Court is back in oral argument season. So, this week we'll be covering a Supreme Court case looking at the meaning of religion. We'll take another look at the Church Autonomy Doctrine in a case reminiscent of a Dostoevsky novel. And we'll close with a case looking at Planned Parenthood, individual rights, and yet another Section 1983 question.
Great. Yeah, that's a good point, Mary Margaret, that we're kind of in a season now when oral arguments heat up. There are cases that we've looked at before, but once they're actually at argument, everybody's interested to see how the justices are treating them and what hints we're getting. And then we'll get another flurry in May, June, July when the court starts to release opinions. So this is an exciting season for the court watchers. So let's get down to it. The first case is one that we covered quite a while ago, before it was cool, as the kids say. So this is the Wisconsin Catholic Charities case, which the Supreme Court took and just heard oral arguments in these past few days. So for those who aren't familiar, or maybe don't remember the details, this case was decided by the Wisconsin Supreme Court last year, and the gist of it was a decision by the state Supreme Court that Catholic Charities was not sufficiently religious to obtain an exemption from an unemployment tax regime because their activities serving the poor and various disenfranchised groups could also be performed by a secular organization, and therefore were not primarily religious activities. We'll get to that. Anyway, Catholic Charities filed for cert. Supreme Court accepted it. Oral arguments just took place. There was a wide array of very good and interesting amicus briefs, including one by the U.S. Department of Justice. And yeah, well, we're going to talk about, I think, some of the underpinning issues and then maybe some of the hints that we've seen at oral argument on how this one is going to go. So I did write on this last year. I don't think it was internal at Napa Legal. I believe this one was at at Blaze Media, but I wrote an op-ed on it right when the Wisconsin Supreme Court had made its decision. And at the time, my main critique was simple and I think fairly obvious, right? This is an extremely narrow judgment as to what a religious purpose is under, in this case, the Wisconsin employment tax law, right? So Catholic Charities purposes are to serve the poor and the disadvantaged, right? They have several programs working with, I don't remember the exact programs in Wisconsin Catholic Charities, but anybody listening to this is familiar with it, with Catholic Charities generally. It might be feeding the hungry, helping find housing for the homeless. It might be helping refugees and asylum seekers. I know they have some job programs working with people with some mental illnesses and things like that. So it's a wide variety of services to the poor and the disadvantaged, right? And so to me, this was just a blatantly insane decision, frankly, right? To say, well, these aren't religious purposes because a secular organization could easily perform the same thing. And in fact, there are secular organizations that do the same kind of services. And the obvious response to that is, well, the problem there is that what you mean by religious purpose, you're trying to cabin it to worship, right? Basically, what are functions that are only done by a religious organization and not by any comparable secular organization, right? So that gets rid of service to the poor, it gets rid of education, it gets rid of pro-life pregnancy resource centers. It would basically mean that a religious purpose is like prayer and worship, because that's the only thing that doesn't have a secular equivalent, and that's crazy. I don't mean to overstate that, but I don't think that's an exaggeration, right? The Anybody who's at all familiar with Christianity, the very heart of the gospel involves the corporal and the spiritual works of mercy, right? So to feed the poor, clothe the naked, house the homeless. These are the words of Christ mandating that his disciples do these things. And so to say that that's not a religious purpose or a religious act to me is just kind of mind blowing. I don't mean to be like, I'm not exaggerating here. This was really a shocking decision. And I do want to point out, so there are critics, and I understand them, of Catholic charities, various Catholic charities, saying that they focus on certain kinds of issues, right? They're more interested maybe in, or some of them, right? This is not one national organization. There are various Catholic charities um, organizations throughout the country and the world, but Catholic charities organizations may focus more on like immigrants and immigration or certain social justice issues, but not others. But that's not the point here, right? Serving the poor and disadvantaged in any form, whether you agree with the method or the priority or not, it's obviously a religious purpose, right? This is responding to the calling of Christ, and to say that that's not a religious purpose makes the whole term religious purpose practically meaningless. So that's the gist of the case. And that being said, when I originally wrote on it after the state Supreme Court had weighed in, I was originally pretty skeptical or doubtful that SCOTUS would take this up, the U.S. Supreme Court, because just frankly, it involves the interpretation of a state tax, unemployment tax statute. And I just wasn't sure it was the kind of case that the Supreme Court would want to bite and weigh in on a religious liberty issue. But the Supreme Court justices were surprisingly clear about the importance of this case. First, by the fact that they granted cert at all, and then by some of the questions that we saw at the oral argument. Um, the Supreme Court seemed to signal that the state court is playing a pretty dangerous game here regarding entanglement and religious questions. Right. So we've covered this in some other cases. We talked about the Huntsman case. I think there was another one in recent weeks, but questions like what is a religion? What is a religious purpose or a religious activity? Is serving the poor and disadvantaged a secular charitable activity or a religious requirement of the gospel? The mere asking of these questions brings the courts out of their proper domain. That seems to have been signaled by justices across the ideological spectrum, right? These are religious questions, and the court is weighing in when they say, well, these particular gospel activities are not religious; they're secular. That's a religious question, and I'm pretty hopeful after seeing the reviews of the oral arguments and seeing how the justices weighed in. Um, I think the Supreme Court has signaled that such questions are not really appropriately addressed by secular courts. And before I pass this on to you, Mary Margaret, I just wanted to share one quote because I think the crossing of ideological divides on this issue is interesting. In particular, Justice Kagan um, said something at oral argument. I have the quote here. She said that it was, quote, pretty fundamental that we don't treat some religions better than others, and we certainly don't do it based on the content of the religious doctrine that those religions preach. So to see someone who generally leans in an ideological direction different from our religious liberty champions on the court, to see her weighing in and saying the way the Wisconsin court came down on this is a problem. Again, it's a mistake to predict the outcome of Supreme Court cases based on the justices questioning at oral argument. But I'm hopeful that the Supreme Court's going to come down on the right side of this, and I'll be interested to see if they do how broadly the opinion is written and what precedent that sets about state religious exemptions to all kinds of laws, not just unemployment tax. So I know I just said a lot, but take it away if you have thoughts on this case, Mary Margaret.
Yes, Frank, I think this is such an important case. I'm with you. I didn't expect it to go to the Supreme Court originally. I listened to oral arguments, and I am I was already glad that the Supreme Court heard this case. It In listening to oral arguments made me realize there is a lot to be said here. Um, I thought that the from based on oral arguments, it seemed like there was a consensus among the justices that the discrimination issue is dispositive. Even the justices who were, so to speak, grilling Eric Rosbach and the other counsel for Wisconsin, even the ones who were kind of grilling them admitted that you can't discriminate among religions and that what happened here was discriminatory. And I think it was Justice Kavanaugh who had kind of a funny line where he said, okay, so you're saying that if Catholic Charities said, repent before they offered their, bowl of soup or their job assistance, then this would all be okay. And the counsel for the state kind of, stammered and was like, "Well, not exactly," and it was pretty. I think it was pretty clear how ludicrous the situation was. Um, One thing that came as a surprise to me was there was kind of a side conversation in the beginning that took up a lot of the time given to Eric Rosbach from Beckett, and it was the justices kind of grilling him on uh, basically whether the exemption could exist in the first place and how to handle issues of commerciality if someone were to say, I'm engaging in commercial activity for motivated kind of purposes. Um, and that's not really what the issue is here. That's not at all what the issue is here. I thought it was, I mean, it's quite hypothetical. That's not what happened here. It's the question is whether you can define religion and then say that it has to include proselytization. That's really what the Supreme Court's holding rested on in Wisconsin. And whatever sort of abstract possibilities are, whatever floodgates arguments, those were not presented. And moreover, and Eric and the other co-counsel clarified that this question of whether uh, allegedly religious activity that is really commercial activity, that issue was already addressed in a case called Living Faith, where a group was running a competitively priced restaurant. They were having promotions, they were doing market studies and undercutting the competition, and they said it was for religious purposes, but the IRS took the position that when you're running a business that's so clearly competitive, it's commercial in nature and it's not exempt. And I feel like a lot of that analysis that's done in the 501(c)(3) context would be very helpful here. And it was interesting that that didn't really come up. And I don't think any kind of floodgates argument undermines the simple discrimination that took place here. So it was surprising to see, 80% of the conversation center around that. So I thought that was pretty interesting.
Yeah, those are really helpful insights. Rather than go on this, why don't we just continue the conversation on church autonomy and all the various times where it's inappropriate for courts to weigh in on religious disputes? Because you have an interesting one here in the next case.
Yes. So speaking of state interference with church matters, we have a case that would seems like the subject of a novel. A priest in Miami, in the Russian Orthodox Church, was elevated to bishop, and the local clergy were, I guess, surprised and kind of concerned by the announcement. And they reached out to their synod, which is, I guess, kind of the equivalent of the Vatican or whatever the mother church, and the mother church then wrote back and said, we don't have any knowledge of this priest's elevation to bishop. In fact, the documents that you received don't look like they were written by us." A church member from the community goes on Facebook and posts a slew of correspondence around this, including the letter to the mother church asking about, expressing concerns about this clergy member. Um, and then the clergy member who was one of the ones who was on the, like, decision-making committee unfortunately passed away during the course of the litigation and was no longer available, for deposition on the case. So, into this sort of drama wades, the U.S. District Court for the Southern District of New York. And as Frank and I were talking about just before the podcast, this has been going on since 2019. The case was originally the defendant's church sought to have the whole case dismissed, a motion to dismiss, which was denied. Went up to the Ninth Circuit Court of Appeals, denied again, and is now most recently summary judgment was granted. So the case is over, and what it all really turned on was um, the question of church autonomy, and so in litigation, the first phase is typically discovery, where the court and the parties just delve into reams of documents, cross examinations, all this kind of investigation of what the other side has been up to. And so in this case, this would mean that the court and the parties would be deposing bishops, subpoenaing materials from clergy correspondence and church records, and the district court judge authoring the opinion just wrote how inappropriate it would be for the court to be deposing on this and then asking a jury to weigh in on it. Um, so the case was favorably decided for religious liberty and for the freedom of the Russian Orthodox Church to govern its own internal affairs. I just wanted to make, since we've had this theme of church autonomy come up a couple times, Frank has covered this in the case Huntsman versus Corporation of the President. We mentioned it also in I believe it's the O'Connell versus USCCB case as well. Um, I just wanted to mention one kind of fun fact or interesting dialogue around church autonomy. There's a lot of debate around whether the issue of church autonomy and this boundary between church state relations or this principle of church state relations, whether it's what's called an affirmative defense or a jurisdictional bar. So, an affirmative defense is something that a party can raise and say, even if everything that has been alleged against me was true, there's nothing you can do about it. That's effectively what an affirmative defense would say. And so in this case, it would be the church saying, even if we did defame this priest, it's not proper, it's not within the scope of the court to hold us liable for that. That was sort of within our authority, and there's nothing illegal about us engaging in those activities. And then the alternative is a jurisdictional bar, which is something that the court will raise even if the parties don't raise it. And it says our court is not equipped to answer this question. This is not fitting for us. We can't get involved here. And so there's this back and forth: is church autonomy an affirmative defense or a jurisdictional bar? And in this case, the court's decision didn't really even get to that. It kind of said it doesn't really matter one way or the other. Um, but we really, I think if I had to put it down, that the district court here kind of took the jurisdictional bar approach and said we, at the end of the day, whether this is whether the allegations are true or not, for us to decide this would require a level of involvement that's not appropriate for this court, and to ask a jury to second guess a group of bishops' decisions about their own clergy would be inappropriate. So, concept of the week: church autonomy and affirmative defenses and jurisdictional bars. And yeah, another interesting case, and I think an important victory in clarifying the church autonomy doctrine. Frank, I'd love to get your thoughts on this, especially kind of your reactions to this in light of all the work you've done around the Huntsman case.
Yeah, I just have one point that I kind of want to make incorporating both. And that's, this one we kind of chuckled at a little bit just because it seemed like the fact pattern was so wild with, Russian patriarchs and then the Russian church outside of Russia and all. It seemed like a movie script, right? But the one thing I want to point out is that as wild as the facts here might be, we don't church autonomy cases don't come from, like, there's no blatant lawsuit where like one church group sues another one and says like, court, please weigh in and tell them that we're right about the Trinity, right? Like that's not that it doesn't come in obvious cases. It always comes under the guise of a secular legal challenge. So at first glance, sometimes they don't look like it, right? Like in this one, so the priest Belia is saying, this isn't. I'm not asking you to weigh in on a religious claim. I'm saying I was defamed, right? Like there were all these implications that I forged this letter. It tarnished my reputation. I'm not asking you to make any kind of religious decision. And at first glance, say, oh, that makes sense, right? There's a secular defamation claim. Courts can weigh in on this, but it requires the court to delve into all these questions of church hierarchy and internal governance, and that's not an appropriate question. Similar to the Huntsman case, right? When Huntsman files this suit, he says, I'm not asking the court to weigh in on any Mormon doctrines. I'm just saying that they said my tithing money wouldn't go to this development project, and it did. And that's that. There's a misrepresentation. I have a secular legal claim here, and actually the majority in the Ninth Circuit there actually just said you don't have a misrepresentation claim on the merits, but the concurring opinion, which I think was correct, said, listen, to get to this question about whether he was defrauded, whether there was a misrepresentation and reasonable reliance on it, we have to answer questions about what is a tithe, right? What is the proper scope of a tithing fund? Is interest earned off an invested tithe still a tithe? These are religious questions, right? So I guess my only point to add to your analysis is just we need to always take a second glance at these, because any church autonomy case is going to come with a counter argument saying this is not a matter of church governance or religious questions. This is a secular matter. And we always want to take a little bit of a deeper look and say, well, what secondary questions does the court have to ask that do delve into religious questions to get to the supposedly purely secular legal argument? I think it's always just worth being a little skeptical when someone brings a church matter up and says it's a purely secular legal concept. All right. Well, with that, we will flip slightly away from church autonomy and talk about one other really interesting case that I think we've covered previously when it was heating up, at least in the weekly email that Napa Legal sends out. So this case goes back several years in South Carolina. If you're not familiar with it, South Carolina's governor issued an executive order a few years back preventing Planned Parenthood from receiving state Medicaid funding in accordance with a state statute in South Carolina. Now, this created a fascinating federalism conversation that I think this is a really good case to draw some lines and figure this out. So basically, Planned Parenthood was completely excluded from receiving any funds from Medicaid patients. Planned Parenthood filed suit, and the dispute recently went up to the Supreme Court. There were oral arguments recently in this one as well. So the oral arguments focus on a very technical question of law, but I think it will set some interesting precedents moving forward. So like I said, this is a fascinating question about federalism. And just to lay this out, here's the issue. On one hand, the funds that are being distributed, they're originally federal funds, right? Medicaid is dispersed through the state, but they come through federal funds. So, as with all federally allocated dollars, there are strings attached, right? The federal government sends in, parameters on this money can only be spent on whatever. So that's legitimate. Anytime there are federal dollars at play, there's also federal policy at play. That's just the way it goes. So federal policy does not allow Medicaid dollars to directly go toward abortion, but it doesn't prevent abortion providers like Planned Parenthood from receiving Medicaid funds for non-abortion procedures. Right. So that's the issue here. Because on one hand, you'll have Planned Parenthood arguing, well, if somebody's getting whatever, sterilization, contraception, something that Planned Parenthood does that is not an abortion, there's no reason that we should be excluded from Medicaid funding, right? And on the other hand, the federal policy that's being argued about here is here's the line from the law. The federal strings attached relevant language here is any individual eligible for medical assistance may obtain such assistance from any doctor or healthcare provider qualified to perform the service or services required. Now, here's the issue. Um, the federal language excludes abortion, but not abortion providers, and says, right, any you can use any doctor, any healthcare provider qualified to perform the services required. That's the federal guideline. But the issue here is that states all have their own medical licensing regimes, right? It's up to each state to determine what is a qualified, who is qualified to perform the services required. To me, that's the heart of the issue, and it's the really interesting argument that was going on here in this case. So, at oral argument, John Bursch from the Alliance Defending Freedom argues in this case that it's up to South Carolina and not the federal government to determine who is qualified to perform the service or services required. And if I understand correctly, South Carolina made this decision that Planned Parenthood is not a qualified service provider for purposes of Medicaid funds. I think that's really the one technical argument that's at play here. But it's an important one, right? Because if it would be one thing if the federal government said something very specific, right? That like any healthcare provider that provides contraception or that provides sterilization is qualified to perform services and to receive Medicaid dollars, that would be a direct challenge to the federalism question, right? Who makes these medical policy decisions? Is it the feds or the state? But in this case, it looks to me as if the federal government actually leaves this to the states because they say, whoever's qualified to perform the service or services doesn't specify who that is. So the default, I would think, is well, you leave it to the state medical boards because they make these decisions about qualified service providers all the time. So I know that's a lot to untangle, and it's easy to get lost in the weeds, but I think that's really the issue, right? Do states have the right to make their own decisions about qualified service providers? Because if they don't, then that's a whole upheaval of our medical regime in this country. So, Mary Margaret, that's really all I have on this. I just wanted to highlight this. I'll be interested to see how this case goes when the decision comes down. But do you have any thoughts on this one?
Well, I really recommend the oral arguments in this case. God bless John Birch for arguing this. He did a brilliant job, and it's obviously such a fraught topic. It was I think it's about as hostile as it can get. And so he had to face that in an already high pressure setting. And I thought that the arguments were absolutely brilliant. I thought it was quite interesting the dialogue around creating rights through a statute. And the ADF points out that that's only the Supreme Court has only found private rights in statutes 4 times before. So most of the time when we talk about rights, we're talking about either the enumerated rights in the Constitution or the unfortunately, or as many would say, unfortunately, unenumerated rights that the Supreme Court has found in the penumbras and emanations of the Bill of Rights. And so this is something different altogether. It's not the Constitution, it's not the penumbras, but it's looking at a statute. Uh, for as a source of minting rights. So that was a new concept for me. I was really surprised by it and actually reassured to find this has only happened 4 other times because I think of rights as being fundamental and I think of statutes as being a bit more tactical. And so um the idea that Congress would create a right through the a highly technical Medicaid regime is an interesting idea, and not to make a floodgates argument, ADF is clear that they're not making a floodgates argument. If they do find a right hidden in the penumbras of this statute, where will it end? I mean, and the other thing that mattered is as since I'm a little bit of a Section 1983 nerd, it all matters because the plaintiff's bringing her claim under Section 1983, saying that, well, I was denied a right, and so I can sue the state in its official capacity for, civil relief, etc. And so it sort of turns on whether the right was minted, because if it wasn't, then the whole sort of jurisdictional hook, the whole hook falls apart. Um, so I'm still processing the idea of statutes making rights, and if this does create a right, um, what doesn't? You know, which statute doesn't? I mean, can I sue a state official for not pulling someone over for speeding because I have a right to to drive around in a like controlled environment? So, I mean, I'm not a big floodgates argument person, but I do think when it comes to rights, there needs to be some kind of limiting principle, and I under the interpretation that the a number of the justices seem to sympathize with, which is that this Medicare statute does create rights. I don't really see what the limiting principle is there. Um, and you can see like also just I don't want to call it an ideological divide, but could hear really the deep legal philosophical divide between the frame of mind that there are just rights everywhere, um, and the more classical view that rights I don't know that there are some parameters or not everything is not an entitlement, I guess, or not every benefit is a right. And yeah, there, it was quite, I thought there was just so much to unpack in the arguments. And I'm looking forward to just continuing to dig in and see some of the scholarship around the case. And I will stop there just because there's so much to say. But yeah, I would love to hear your thoughts, Frank, on specifically the right minting factory.
Yeah. Yeah, it was a little bit of a surprise to me. I've never really thought about rights in this sense being created by statute because, like you said, it's so foreign to the way that we normally talk about rights. But one thing I wanted to ask you, because I know you know Section 1983 much better than I do, but just looking at the plain language of Section 1983, it I'm confused as to whether there's a legitimate claim here because the language is that you have relief or opportunity for relief under 1983 if you're deprived of any rights, privileges, or immunities secured by the Constitution and laws. So that's interesting because I would assume that if assuming that statutory rights are a thing, right? Um, Separate from what you find in the Constitution, I would think that this would be written to say any rights secured by the Constitution or laws of the United States or statutes, something like that. But to me, that you could read this statute in a way that says if it's not a constitutional right, it doesn't fall under 1983. I don't know. Maybe that's because I'm not a savvy, person to be interpreting 1983. I'm not experienced in this, but by the Constitution and laws seems to mean that it has to be a right secured by the Constitution. Is that a misread?
No, I think that to me that's a faithful reading. It's reading it as conjunctive, and it would be consistent with the 4 times that the Supreme Court did find rights in statutes. The rights they found were one of the 4 was in an act entitled the Civil Rights Act,
Mhm.
which we all know was sort of a tactical enforcement of like the 14th Amendment. So it was sort of uh kind of a package, a package deal. And so I think that's a great way of putting it, that like where this isn't being sort of joined with another constitutional right. I mean, I guess what a devil's advocate would say is that the unenumerated right of reproductive autonomy would be
Right.
the uh counterpart to this, but again, there are 2 things I would think I say cut against that, which is 1, there are no signposts, like, the Medicare Act is not considered it's not called reproductive rights and Medicaid Act. So there was no clear link. And John mentions that in his arguments. And then the other is, if a bill had been passed standalone, saying, "Hey, we are granting a right to we're granting a right to abortion. We're granting the right to an abortion provider of your choice." Um, would that pass? I don't know. I don't think so. And I think the fact that it wouldn't is sort of like a gut check of, well, then if it wouldn't pass, it's probably not what they said, you know?
Yeah. Yeah, no, that's a great point. I know some of our listeners are constitutional law scholars and professionals. So if anyone wants to weigh in and tell us more about what they think about this 1983 claim in particular, please, most of you know where to find Mary Margaret or myself. Shoot us an email. I'd love to hear more from someone who really knows this area.
Well, there's so much to say, but we'll stop for now. Thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy our content, we would appreciate if you would like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us again next week as we continue to highlight and discuss some of the most important ongoing legal issues facing faith-based nonprofits and affecting religious liberty.
We'll talk to you next week. Thank you for joining us, and God bless you all.